policy, human rights, impacts of sanctions. Afterwards, like now, we will have time for questions. Dr. Stυλιανού, you may come.
Thank you very much. And I think after such a powerful and quite informative speech on issues of recognition legitimacy, but also on the face of what is actually being developing at the time we're actually talking, I think we can easily conclude, without me having to give a speech on sanctions, that international law is living through tectonic changes and tectonic shifts. However, I do have prepared a speech on the issue of policy, people, but also the impacts of sanctions on human rights. And sanctions are often described as a peaceful alternative to war. Yet, for many people around the world, they do not feel peaceful at all. Because sanctions may be negotiated in diplomatic language and written into legal frameworks, but their consequences are experienced somewhere else entirely. They are experienced in the everyday lives of people. Ladies and gentlemen, it is therefore a great honor to address you today at the Helga Pedersen Moot Court competition, named after a figure whose work was devoted to strengthening the protection of human rights within the Council of Europe. The European Code of Human Rights reminds us of a fundamental truth. International law is not only about relations between states. States do what they do since ancient times, since the beginning of the presence of the human person on earth. International law has been in existence. Maybe we are calling it with different names. Jeremy Bentham's definition of international law came much later. But from the cavemen and women, when they went outside their caves, outside their territories, and they started doing what? Communicating. And how people at that time, at those very ancient times, started communicating. They started communicating by killing each other. The use of force is a very fundamental basis for international law, and thus, in the modern developments of international law, the United Nations Charter, adopted in 1945, clarifies and starts with the fundamental belief that we, the peoples, using the plural, the peoples of the United Nations, determine to stop the scourge of wars, providing also two main prohibitions on the use of force. The prohibition enlisted in Article 2, Paragraph 4 of the United Nations Charter, prohibiting the actual use of force or the threat to use force. And secondly, the Article 2, Paragraph 7 of the United Nations Charter, principle of non-intervention in the internal affairs of another state. And I'm telling all those things because the current geopolitical, but also international law perspective changes. And in light of those changes, we need to also assume and provoke, but also promote the essence and the importance of human rights in those turbulent times we live into. So international law being the relation between states, it's also about the protection of individuals. And that's particularly relevant when discussing sanctions, because sanctions may be designed as instruments of policy, but their consequences are ultimately experienced by people. Tonight, or this afternoon rather, I want you to reflect on a question that sits at the intersection of international law, geopolitics, and human dignity. What are the human rights impacts of sanctions? I will tell you a very quick example. That's a true example. A few years ago, a doctor working in a hospital in a sanctioned country described a moment that stayed with him forever. A young child had been brought into the emergency room suffering from a severe infection. The treatment required a very simple antibiotic, a medicine so common that in most parts of the world it is taken for granted. But that medicine was not available. Not because it didn't exist. Not because doctors did not know how to treat the child. It was unavailable because the financial channels needed to import it had collapsed under sanctions. The doctor later reflected. The sanctions were not written for this child, but this child paid the price. And this story reminds us of something fundamental. Sanctions are designed in ministries and foreign policy offices. They are negotiated in diplomatic parlance, in diplomatic language. They appear in legal documents, such as the Security Council resolutions. But their consequences are lived somewhere else entirely. They are lived in homes, in markets, and sometimes in hospital yards. And this brings us to the central topic of today's discussion, which is a question, again. How do policies designed to influence governments end up shaping the lives of ordinary people? The main point is to balance between policy-oriented deliberations or issues that are relevant to the imposition of sanctions, but also address the question whether economic coercion can ever remain morally neutral. And to answer this, we must move from policy analysis to human consequences. And there are a lot of dimensions when we're taking into account the human rights aspects of sanctions. Because sanctions usually, and by definition, collide with fundamental human rights. And this is very relevant when, for example, we're discussing whether sanctions work And it's not only the question, what is the actual result of sanctions in foreign policy? Because states, but also international organizations, impose sanctions in order to achieve a result. But then that result needs to be a very specific result that also needs to be drafted within the resolution authorizing the result of sanctions. Otherwise, as I told you at the introduction of my speech, those sanctions will definitely collide with human rights and, most importantly, with fundamental freedoms. And those sanctions will be something that people, ordinary people, will feel. Therefore, there is definitely the notion of the sanctions being used as tools of international policy. And they have been actually used as one of the most widely tools of international pressure. They are used to enforce international law when international law is being violated. They are used to respond to aggression. They are used to respond to threats to use force. They are used to respond to actual uses of force. They are used to deter human rights violations. So very importantly here, we need to understand the deterrent effects, as we talk about it in law, of the sanctions, of the punishment that is being put upon the perpetrator of a violation of international law. Sanctions also impose pressure upon regimes without using military force, but again that's subjected to Chapter 7 of the United Nations Charter, which includes the forcible measures in order to stop violations of international law. But nevertheless, we can easily conclude, when we're examining the topic of sanctions, that those sanctions promise something seductive to policymakers, a power without a war. And those examples can be mentioned briefly in relation to examining the historical perspective on sanctions. We do have plenty of examples, especially in the modern era of international law, examples that have been and can be linked to the previous presentation in relation to failed, non-failed states, in relation to entities that want to become states, but also we do have to take into account, when we're talking about international law, the effect of non-state actors that might include references. My esteemed colleague earlier did mention the so-called, in inverted commas, Turkish Republic of Northern Cyprus, that is not recognized by any other state in the world except Turkey, which is the occupier since 1974 of 37% of the Republic of Cyprus. So those examples of sanctions will include cases like Iran, cases like Russia, cases like North Korea, cases like the most very recent example, Venezuela. But sanctions in those cases were not really successful in the sense of deterrence, in the sense of stopping autocratic regimes, or in the sense of stopping gross human rights violations that were or have been taking place in those plenty examples that I can narrate. But nevertheless, we do need to take into account that sanctions have since then evolved. And that evolution takes us to the paradox, as I will call it, to the paradox that takes into account the necessity of imposing sanctions to authoritarian regimes, the necessity of imposing sanctions to regimes that violate the human rights and fundamental freedoms of their citizens, the necessity of imposing sanctions to deter, and I repeat and I highlight the word deterrence of human rights violations, but on the other hand, and that's the paradox or the oxymoron, the effect of those sanctions in daily lives. Therefore, I will argue that this paradox of defending human rights by imposing sanctions need to take into account the inherent risk of violating human rights of ordinary citizens. Thus, the paradox talks about a necessity, but also, on the other hand, talks about taking into account the daily circumstances and the effect of those sanctions on the daily lives of people. Therefore, a comprehensive regime of sanctions needs to take into account not only that principle of necessity, whether it is absolutely necessary to impose a specific set of sanctions, but also, and most importantly, since my background is international law, and whenever I'm referring to international law, I do note the two fundamental principles, the bedrock of any actions in international law, which is necessity, whether it is absolutely necessary to take action. So I'm starting defining further and elaborating on the notion of sanctions, but having necessity on the one hand, you also have, in order to balance such sanctions and such effects, the principle of proportionality. So sanctions need also to be proportional to the effects of the sanctions when those are being imposed on the daily lives of ordinary people. And whenever I'm referring to the daily lives of ordinary people, apparently I'm referring to the human rights and fundamental freedoms of people. Therefore, sanctions need to be targeted. Sanctions, most importantly, as technology has evolved, we now have the evolution of AI, of artificial intelligence, the evolution of new technologies. We're all having and talking about smartphones. Sanctions can also get smart. And there are very specific ways whereby sanctions can get smart, by being more proportional, by being more applicable to the actual threat that is being relevant for the purposes of imposing sanctions. Sanctions also have a very detrimental economic effect. And whereas sanctions aim at governments, economies also are being affected. And while economies are being affected, people also are being affected. There are indirect effects relevant to the present discussion on the human rights dimension of sanctions that will include the economic contraction, that will include the collapse of currencies, that will include the disruptions of supply chains, that will include, in my first example, with the child, with the vaccine or the antibiotic, medical shortages, and therefore sanctions do not really practically punish elites. They often reshape the social fabric of entire societies. And in the courtroom, when you go into a real court, and when you face the judge, the perpetrator, and the victim in front of you, the notion of punishment is very relevant. So whenever there is a breach of the law, punishment has to be imposed. But in that sense, whenever we're talking about sanctions, such a concept appears abstract. So in the courtroom or in our universities, in our lecture rooms, sanctions are abstract. They do not affect us. When we are resolving to impose sanctions in a faraway place from us. But in the hospital yards, sanctions become painfully concrete, and they can be felt. The legitimacy of sanctions, ladies and gentlemen, cannot be measured only by the pressure they exert on governments, but also by the suffering they impose on civilians. And this leads us to the central dilemma of modern international law. I'm sure I had slides about those things, but as usual, I've forgotten to press the button. Sometimes it's good not to press buttons, as other people are pressing buttons right now, sending missiles, UAVs all over the Middle East, but I will try to catch up with the slides that I had. There are legal and ethical dilemmas in relation to sanctions. We talked about the normative paradox. We talked about sanctions being used in the name of the protection of human rights, whereby each coin has two sides. So at some point we do need to take into account those things. We know that sanctions generate human rights harms, and we do face the paradox in modern diplomacy with measures designed to defend human dignity, but sometimes undermine it. And if international law seeks to humanize power, sanctions must also be humanized. Therefore, we need human-centered sanctions that will offer a constructive thinking of the whole notion of imposing sanctions. Because when you're imposing sanctions, it means by definition that there's a harm that has been done on human rights. The issue of preventing human rights violations is extremely relevant for policymakers, but lawyers and international lawyers alike. Therefore, a sanctions regime that ignores human suffering risks losing its moral authority. And the role of law, courts, but also future lawyers like you, is that we need to be able to scrutinize sanctions. Do create a critical legal thinking of not just accepting anything that is being imposed upon you, but do create the thinking of promoting, respecting, and also protecting human rights. This is a moot court competition on themes relevant to human rights. And you are the future for the promotion and protection of human rights, since you have expressed and shown your interest and determination to be here and participating in this great event. So when we're looking for who will take into consideration those dilemmas and those paradoxes that I have delineated very briefly in my speech, and when we're asking ourselves where to find those people that will stand firmly there, rigidly, powerfully, for the purposes of promoting, protecting, and respecting human rights and fundamental freedoms. So when we're looking for that person, you have to look around. You have to look who is sitting next to you, who is sitting in front of you, who is sitting behind you. And those are the future lawyers. Those are the future defenders of human rights and fundamental freedoms. And I will conclude by saying that sanctions need to be disoriented from policy and need to take into account the human perspective. So from policy, whenever we're talking about sanctions, we need to move to people. Thank you very much. I will assume that you might have questions. I always say to my students or to the audiences I talk, it's always, the first question is always the most difficult. So let's move straight to the second one. There is no question. Thank you very much for your attention.